All right, folks, if we can take our seats, I will call this hearing of the Judiciary, Finance, and Civil Law Committee to order. Today is March 7th, 2023. We do have a quorum present. We've got a big, busy day ahead of us. The first item on the agenda is the minutes. Do I have a motion to approve the minutes of March 2nd, 2023? Representative Carroll moves the minutes of March 2nd, 2023. Any discussion to the minutes? Seeing none, all those in favor, please say aye.
Aye.
Opposed? Minutes are approved. All right, first bill up, Representative Long. No longer on our committee. I will move to re-refer House File 2023 to the Public Safety Finance and Policy Committee. I understand you have a couple of amendments. I'm going to move the simplest one first, the A5 amendment. My understanding is that's just a technical amendment to correct a drafting error. Is that correct?
That is correct, Madam Chair.
All right. Any discussion to the A5? All those in favor, please say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Moving on, Representative Long, do you want to do the other two amendments first before we get to the presentation? Great. I will move the A3 amendment. Representative Long, please tell us what the A3 does.
Chair Becker-Finn, the A3 is to set up an appropriation to help with juvenile record expungement. So in the process of preparing the bill for reintroduction this year, we heard from a number of practitioners that many juveniles, even though they're eligible for expungement, don't often take advantage. And so this is trying to set up a grant program to help make sure that juveniles are aware of their ability to seek expungement and are provided some assistance in that process.
All right, and I see that's to the Commissioner of DPS, and we are sending this to Public Safety, so it being a blank appropriation. Any discussion to the A3 amendment? All right, seeing none, all those in favor, please say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. The A4 amendment, I will move the A4 amendment. Representative Long, please tell us about the A4.
Thank you, Chair Becker-Finn. So the A4 will help provide additional protection to employers for hiring individuals with expunged records. And so this is something that had been the intent of the bill, but hadn't actually been in our language. So we wanted to make sure to clean that up.
All right. Any discussion to the A4 amendment? All right. Seeing none, all those in favor, please say aye. Aye. Opposed? Motion prevails. The amendment is adopted. All right. We now have the bill in the form you would like it. Representative Long, please tell us about your bill.
Thank you, Chair Becker-Finn. So the Clean Slate Act has a really simple premise, which is that we should give those who have paid their debt to society an opportunity for redemption. Too often, having a criminal record severely limits an individual's opportunities to find jobs, housing, or education. And I, for one, have heard many moving personal stories from my constituents about individuals who have struggled in the past and are trying to turn their lives around, but come into barrier after barrier in terms of finding new jobs or finding the ability to seek the educational opportunities they'd like. 1 in 4 Minnesotans have some type of criminal record, and 90% of employers conduct background checks. So when you put those two numbers together, that adds up to a really significant barrier to employment for tens of thousands of Minnesotans. But our current system of opt-in expungement by petition isn't cutting it. Too many people don't know they're eligible or don't take advantage. There are barriers in terms of time and legal costs to pursuing expungement by petition. In 2019, there was a study in Michigan that found that just 6% of eligible people obtained expungement through petition within 5 years of eligibility. And I would expect we'd find similar numbers in Minnesota if a study was done here. This bill is similar to broad bipartisan efforts we've seen enacted now in 10 states, including Utah, Pennsylvania, Virginia, and Oklahoma. In Utah, the bill passed unanimously. In Pennsylvania, the vote was 181-2. In Michigan, after the bill was passed, those who have had records expunged saw their average wages increase by 25%. We're facing a real workforce crunch in our state. Giving employers the peace of mind that these crimes would no longer need to be part of a background screening would help them hire and would help expand their worker pool. The bill also builds on the leadership of many of our county attorneys who are currently working to expunge old records. Prosecutors have initiated expungements for old misdemeanors like these, particularly in metro counties, but not all counties have the same resources to pursue these options, and so there are regional inequities. The County Attorneys Association has been a terrific partner in this effort, with several county attorneys dedicating many hours to helping put this bill together over many years. The Clean Slate Act would automatically expunge records for certain crimes after a crime-free waiting period. It excludes enhanceable offenses, person offenses, or criminal sexual conduct. It contains important protections, including allowing continued law enforcement access to records. It also allows Department of Human Services access to records for sensitive employment background checks. And this year, we are adding that pardons will be automatically expunged as well. This is the third session I've brought this proposal, and I am grateful for the bipartisan support this bill has received in the past. We have a very broad organizational support that we've received, and hopefully folks have the handout with the many logos of support. But I'll just mention a few, which include organizations like Violence Free Minnesota, Minnesota Coalition Against Sexual Assault, the Catholic Conference, Americans for Prosperity, and many more. This bill is an opportunity for rehabilitation and for better economic opportunities, which we know reduces recidivism. It's about offering hope and offering second chances. Thank you, Chair Becker-Finn, and I have a few testifiers I'd like to bring forward now.
All right, thank you, Representative Long. We've got Gina Evans is first on the list, and then Chaz Anderson is next. When I tell you you're next, if you could move a little closer and get ready. We've got a full agenda today. All right, please introduce yourself for the record and proceed with your testimony.
My name is Gina Evans. Thank you, Chair Becker-Finn and members. Thank you so much for the opportunity to speak on this very important issue. My name is Gina Evans, and I am a member of the Legislative Affairs Committee for the Second Chance Coalition. I see several familiar faces, but for those of you that don't know me, here's a little background. After 15 years of IV meth addiction, bad relationships and criminal behavior, I wound up in Shakopee Women's Prison 3 different times. I found freedom from my substance use disorder at Minnesota Adult and Teen Challenge. My crimes range from 5th-degree possession and check forgery to financial transaction card fraud. I take full responsibility for my terrible behavior and fully understand the impact that it had on my community. I look back on that time now, and I look back on that time in my life, and it feels like a book I read or a movie I saw, because that Gina that committed those crimes no longer exists. In July, it'll be 20 years that I've been free from chemicals. 20 years is a big milestone, and I can tell you that I knew for certain by 3 or 4 years of sobriety and healing from my trauma that I was never going back to that lifestyle of drugs and crime. I was just on the background eligibility task force, and we had some experts come in and testify in both the area of criminal behavior and substance use disorder, who said after 5 years, the risk of return to symptoms drops dramatically by like 85%. Anecdotally, I see this over and over again in the recovery community and my friend groups. I received a pardon extraordinary in 2016 from Governor Dayton, Chief Justice Gilday, and Attorney General Lori Swanson. I was very grateful for that honor. 20 years crime-free and a pardon. You would think that that would clear your record, but unfortunately that is not the case. I went down to the BCA just a couple of weeks ago and pulled my criminal record because I'm working on expungements right now. After a pardon, the only thing that actually changes is that my BCA report on the disposition changes to pardoned. For landlords and employers that don't know or understand the law, it might as well still be there. So now I'm working on getting all my crimes expunged one by one. Thank you for taking the time to consider these changes to Minnesota law. There are other folks just like me out there who have made mistakes but have changed their lives, worked really hard to change their lives. People who have the potential to do and be so much more, if only we can remove barriers to success in employment and housing and allow this path to redemption. Thank you for your consideration for the Clean Slate Act.
Thank you for your testimony, and congratulations on your sobriety and your clean slate.
Yes.
Chaz Anderson, please introduce yourself for the record and go ahead with your testimony. We have Grace Waltz on deck.
Good morning, Chair Becker-Finn, Lead Scott, and members of the committee. For the record, my name is Chaz Anderson, and I'm here representing the Justice Action Network. The Justice Action Network is the nation's largest bipartisan criminal justice reform organization, working at the federal level and in 20 states, including Minnesota, since 2016. Since 2019, an informal group of stakeholders in Minnesota have been meeting and evaluating the possibility of moving to an automatic expungement system for certain offenses. Back in 2019, when we started meeting, Pennsylvania and Utah were the first states to pass automatic expungement laws. Over the past 4 years, we've drafted, introduced legislation for consideration by the legislature, continued to work with stakeholders, and consulted with other states. And today, I can say there's 10 states with now automatic expungement process, and House File 2023 is the product of all this work and engagement with stakeholders. I'll point to 2 studies from Michigan and Minnesota as it relates to expungement policies that illustrate why this is an important economic issue. Both studies found that cumbersome petition-based systems fail to provide the relief as they intended. The 2019 study in Michigan that House Majority Leader Long referenced found that 6% of eligible people obtained expungement within 5 years of being eligible. The Minnesota study from Santa Clara University found that just 5% of people with records eligible for relief received it under the petition-based system. In addition, that same Minnesota study found conservatively that there's an annual wage gap of about $5,100 between individuals who have expunged records versus individuals who do not for same and similar offenses. The study estimated that $2.4 billion in cumulative earnings are lost every year in Minnesota due to this gap. So what does closing this gap mean for Minnesota? It means fewer individuals reliant on social services, more tax revenue for the state, but more importantly, the opportunity for individuals to seek improvement in their lives and for the lives and benefits of their families. Lastly, an important feature of this bill, House File 2023, includes employer and public safety protections and for the ability of law enforcement agencies to access expunged record data at any point in time. Madam Chair, members of the committee, thank you for the opportunity to testify today.
Thank you for your testimony. Next up, I have Grace Waltz, and then I have Bob Small next, if you want to come on up. All right, please introduce yourself for the record and proceed with your testimony.
Thank you, Madam Chair, Representative Long, and members. My name is Grace Waltz, and I serve as the Vice President of Public Policy at the Minneapolis Regional Chamber, and I'm here today to testify in support of House File 2023, the Clean Slate Act. As the largest local chamber of commerce in the state, representing businesses across the Twin Cities region, we know the importance of having trained and skilled workers. As we continue to grapple with an extraordinarily tight labor market, that need is more important than ever. We believe this legislation will help provide a pathway for workers to help fill this void. Unfortunately, there are many obstacles for individuals with criminal records who seek to better their lives but face barriers in education, housing, and employment. According to the Brennan Center, the number of Americans with a criminal history has increased significantly over the past 30 years. Today, nearly 1/3 of working adults have a criminal record. Our country now has roughly the same number of people with criminal records as they do with college degrees. These numbers do not include people who were arrested but never charged or individuals who were acquitted. As we look to our workforce in the next decade, employers need trained and skilled workers. When we testified in support of this bill in previous legislative sessions, we spoke of the worker shortage that was bound to continue even in a post-pandemic world. The need for workers across all sectors and industries is still very real. Employers are looking for creative solutions, and this legislation provides a much-needed opportunity to expand our talent pool. This bill will allow for a pathway for individuals to receive automatic expungement for certain convictions while still maintaining public safety access to those records. We're also pleased that this bill includes important protections for employers. This will make an enormous difference for individuals who are seeking to enroll in post-secondary education options, training programs, obtain occupational licenses, and secure stable housing. Thank you for the opportunity to provide our support for this important legislation.
All right, thank you for your testimony. And Executive Director Small, please introduce yourself and proceed with your testimony.
Thank you very much, Madam Chair. My name is Robert Small. I'm the Executive Director of the County Attorneys Association, and I am proud to be here to add the County Attorney's support to this very important bill. I'd like to thank Majority Leader Long for his perseverance and his willingness to grab a lot of people and put them together and work very hard to get the bill in the form that is before you today. And so I am proud that the association is a signator of with many others, in support of this bill. So thank you very much and hope you would pass this bill.
All right, thank you for your testimony. Are there any other members of the public wishing to testify on this bill? All right, seeing none. Representative Long, you can come back up. Discussion to the bill. All right. Oh, Representative Scott.
Thank you, Madam Chair. And Representative Long, on the bill, on 4.4, there's a citation there, 609A.02 sub 3. Could you elaborate on that section and what it addresses in your bill?
Representative Long.
Chair Becker-Finn, Representative Scott, yes, this is a reference to the existing petition-eligible felony expenses, which the legislature in the past has enumerated and I think is also included in the bill language on pages 8 and 9. And so these are offenses that are deemed to be relatively minor felonies, and so they are ones, I'll give you a couple examples. There's willful evasion of fuel tax, altering livestock certificate, rustling and livestock theft. So some of these aren't ones that come up that often. The one that would probably come up most often, I think, would be fifth-degree drug possession. And so hopefully that answers your question.
Representative Scott.
Thank you, Madam Chair and Representative Long. Do any of them have to do with interference of privacy?
Representative Long.
Thank you, Chair Becker-Finn. I might phone a friend for House Research who might know the list better off the top of his head than I do.
Mr. Johnson.
Madam Chair, members, Ben Johnson from House Research. Interference with privacy being a broad term, I don't think there's anything that falls specifically under that sort of description. There are over 50 offenses on here. Primarily, as Representative Long noted, they are relatively minor offenses. There are some theft-based offenses. There's some telecommunications and information services fraud. There's a computer theft, a cellular counterfeiting. So to the extent that those would fall under that general category that you're talking about, that's possible. I'm not sure if that answers the question.
I will note on line 9.27, I know when I'm scanning through here, 609.746. I don't actually know what that crime is off the top of my head. I'd have to look it up, but it does say interference with privacy subsequent violations. I don't know what that, we may have to look that up. I don't know. Representative Scott.
I've got the statute book, but thank you, Madam Chair. So Representative Long, 3.24, I guess I had the wrong citation. It's 609.746. Has to do with interference with privacy. So I don't know if that helps Mr. Johnson or not. I just know, the reason I bring it up, members, is we've heard a lot of bills even just I think last week or maybe the week before and over the years about people putting cameras in wrong places and interfering with people's privacy. And I just want to make sure that this is not letting those folks have a clean slate.
Representative Long.
Thank you, Chair Becker-Finn. So on 3.24, these are the exceptions from misdemeanor offenses. So any misdemeanor offense other than interference with privacy. As Chair Becker-Finn noted, there is the separate crime that is included in the current expungement eligible And that's not one I'm familiar with, so I'm certainly willing to dig into that and follow up with you. The bill has one more stop in public safety, but our intent certainly is to exclude criminal sexual conduct type crimes from eligibility for automatic expungement.
Representative Scott.
Thank you, Madam Chair. I don't know if Mr. Johnson wants to elaborate on that anymore. Not really?
No, I know there are a lot of members sitting on this committee that are also on public safety, so I'm sure we can work with Representative Long if it's appropriate to make a change. That's possible. I see some nodding heads from my public safety.
All right, thank you. I'd appreciate that.
Yep, thank you. Representative Johnson.
Chair Becker-Finn, Representative Long. I'm trying to get all the wording. It's a lot of things listed in this bill, and I think I wanted to make sure that, let's see, on line 3.15, it deals with 609-2231, assault in the fourth degree, that those were not automatic or eligible for expungement.
Representative Long, I think you just explained this, but if you could clarify, some of the crimes listed are things that are eligible, and some of the crimes that are listed in the bill are things that are not eligible. Representative Long.
That's correct, Chair Becker-Finn. So it's a little confusing to read through, but essentially the entirety of page 3 are exemptions. So those are not included for automatic expungement under the bill. It's any misdemeanor offense other than the list that follows.
Representative Johnson.
Chair Becker-Finn, Representative Long, that was the issue, because in subdivision 4, it says eligibility, certain criminal proceedings. You have the ones that are allowable, that are eligible, and that eligibility is in bold print, but then when you get down to the ones that aren't, it's misleading, because those are all listed in the eligibility section. So it makes it real confusing the way this is, unfortunately, the way it's drafted. I think you need to do an amendment to get excluding in bold print so people understand better.
Representative Johnson, I find a highlighter helps. Any further discussion to the bill? All right, closing comments, Representative Long.
Thank you, Chair Becker-Finn. Thank you, members. This has been a bipartisan bill for many years. As mentioned, we have a really broad coalition behind it. And the goals, I think, were said very clearly by Gina Evans, that we are trying to give people the opportunity to get their lives back, and often even those who've worked as hard as Gina has to get her life back struggle with the expungement process, and this is one way that we can make it a little easier for them to get jobs, get access to housing and education.
All right. With that, I will renew my motion to refer House File 2023 as amended to the Public Safety, Finance, and Policy Committee. All those in favor, please say aye. Aye. Opposed?
No.
Motion prevails. The bill is on its way to public safety. We'll see you soon in public safety, Representative Long. Thank you. Next up, I've got Representative Hollins. Okay. Understand. We get Representative O'Neill co-presenting with you today. I will move to recommend that House File 865 be placed on the General Register, and we'll turn it over to our dynamic duo here this morning.
Thank you so much, Madam Chair, and thank you, committee members. I really appreciate the opportunity to be here.
Thank you.
I was like, oh, sorry. I appreciate the opportunity to be here with you. I kind of miss being in this committee, but I don't miss the 8:30 start time. Not gonna lie. So we're here with House File 865, which is a bill about basic fairness and reducing barriers for small construction businesses. It's a common sense bill. It has bipartisan support, and it has the support of 24 organizations, including labor unions, management, the trial lawyers, and the Minnesota Council on Latino Affairs. It's often referred to as the duty to defend bill because it ensures that each party to a construction contract only has to defend to the extent of their own negligence. As a little bit of background, in 2013, the legislature passed a law that prohibited general contractors from requiring subcontractors to purchase insurance that would cover damages caused by the general contractor's negligence. Currently, many general contractors require a project-specific insurance or include duty to defend language in their contract agreements. That means that smaller, less powerful subcontractors are responsible for purchasing insurance to cover the negligent acts of the general contractors or pay the general contractor's cost of defense in a lawsuit. This bill realigns the concept of indemnity and defense and revives the spirit of the 2013 indemnity law. And it does so by doing three things. It ensures that a negligent party pays their own legal fees, it aligns the Minnesota practice with the American rule, and it removes ambiguity to ensure that the public projects we fund are performed fairly. I'm going to turn it over to my co-presenter, Representative O'Neill, to talk about her experience with the bill.
Representative O'Neill.
Thank you, Madam Chair. It is great to be back here, too, but I also don't enjoy the 8:30 start time, but this is great.
None of us do.
Yes, Madam Chair, and you have young children, so even more difficult. Thank you, Madam Chair and members. So I actually had carried some versions of this bill in the past. To me, this is an issue of absolute fairness. I had owned my own subcontracting tile setting company, and now my son is an owner, so we passed it on to the next generation. And they are still struggling with this issue. I thought we had put this issue to bed, but we have not. And you know how very clever lawyers find ways to get around things. Well, and I know the room is full of lawyers, forgive me for saying that, but they are very clever, and I believe that this is one of those opportunities where we can put right what the spirit of the law actually was. So I really appreciate being a part of this. I think this is important for the little guy, the small subcontractors. And in my community, if you drive about 6 o'clock, 7 o'clock at night, sometimes even 8 o'clock, because these people work very late, very, very late hours, because they are their own bosses. My entire community is full of work trucks and work vans, and this would impact my community tremendously. I know when I did this the first time, when I was the author of this bill, it is a huge impact for the little guy. And even so, someone like my son, who's just starting out, he's 28 years old and trying to, eventually he's going to go out on his own. Right now, he's still within the company that we started. But it is really difficult. And this is just one of these difficulties where you have to bear the burden for something that you didn't do. And that's really unfair. This is a basic issue of fairness. And so I know you'll hear from the subcontractors and a few others about this bill. But in 2013, I really thought we had this kind of put to bed and fixed, and we don't. And so I would really appreciate your support moving forward to support really what the intent of the 2013 legislation was, so that they truly only defend what they did wrong and not anything that any contractor did on the job site, as kind of what it was in the past. So I appreciate your support.
All right, thank you. And we do have a couple testifiers signed up. First, I have Patrick Lee O'Halloran, and then I have Tamara Sunby on deck. And please introduce yourself for the record and then proceed with your testimony.
Good morning. Thank you, Madam Chair, committee members. My name is Patrick Lee O'Halloran. I serve as the Minnesota Subcontractors Chapter Counsel. I'm also a private attorney at PJL Construction Law and ADR, and I've specialized in construction law for more than 20 years. Thank you for hearing this important bill. I ask that you pass it. The bill is needed because there is a significant imbalance in bargaining power in the construction industry. This imbalance has led to an unfair practice of shifting legal costs and insurance costs onto the smallest subcontractors in Minnesota. As you've heard, in 2013, the legislature amended the anti-indemnity statute to make it clear that indemnity agreements in construction contracts could only hold contractors responsible to the extent of their own fault or negligence. This may seem like common sense, but the legislature had to address it back then. After that law passed, lawyers for general contractors began drafting contracts that got around that law by increasing the obligations to defend general contractors, even if the general was solely negligent. In your materials, you have an excerpt from an actual contract between a general contractor and a disabled veteran subcontractor on a MnDOT job. The general contractor on this publicly funded job is requiring the subcontractor to pay all of the general contractor's legal fees throughout any dispute, even if the subcontractor doesn't cause the damage and can't be required legally to indemnify that general contractor. Today in Minnesota, subcontractors are regularly being contractually required to defend the general contractor, even where that general contractor is solely negligent. This practice is unfair and creates a host of problems for small businesses, financial and legal. For example, these duty to defend clauses are common and often non-negotiable. So the discussion is simply, are you going to sign the contract? And if you're not going to get the work. If a subcontractor wants the job, but doesn't want to agree to those terms, they have to then incur additional legal fees to try and negotiate away the unfair terms. If a contract is signed, these terms impact the way that subcontractors approach the entire job, and they chill the subcontractor's use of their legal remedies and other contracts, leaving these subs to feel they have no legal options. We also know this practice hurts DBEs trying to make headway in the industry. As they face increased risk to cover risk shift.
Phone a friend.
Pardon me. A quote from the joint disparity study points out that duty to defend contract requirements, retention, withholding, and prompt payment issues cause challenges for small firms in the Minnesota marketplace. Also from the joint disparity study, quote, public sector insurance requirements are a barrier to businesses seeking public sector prime contracts and subcontracts. Finally, if a claim does arise, subcontractors can and do face the risk of significant liability, even if the claim arises outside of their control and they're not responsible for it. If the claim is going to be settled, which most claims are, the first thing parties look to is to determine who pays is the contract, often with the same terms as the one before you. So yes, unfair settlements are structured because of this practice. Now, when a similar risk transfer practice afflicted the Minnesota trucking industry, the legislature passed a law to prohibit it. That's Minnesota 221.87. The trucker statute used the same indemnify, defend, and hold harmless language as this bill proposes. Numerous states in the Midwest and Rust Belt have near identical laws limiting indemnity and defense to the same extent that this bill proposes, including Iowa, Oklahoma, Colorado, and Montana. Passing this bill will not make Minnesota an outlier. It will be following the more common trend, which is limiting unfair risk transfer to a reasonable extent. I'll quickly walk you through the bill, which has three basic parts. For simplicity, start on page 2, please. Section 4, line 2.22, adds the word defend to the definition of indemnification agreement in Chapter 337.01. This closes the loophole that I just talked about that allows a negligent party to make someone else pay for and insure their legal costs. Just like the current law for indemnity agreements, the addition of the word defend means that the separate defense obligations would only be enforceable to the extent of a party's own fault or negligence. Next, Section 5, line 3.3, deletes the term project-specific insurance. This is ambiguous wording, which some have tried to argue is a full exception to the anti-indemnity law. Again, the law prohibits a general contractor from requiring a subcontractor to buy insurance for the general contractor's own fault, negligence, or breaches. You shouldn't be able to get around that by requiring it simply to happen one project at a time. If you want an article explaining how that ambiguity has been taken advantage of, we'd be happy to send you copies. It's also important to note that the Insurance Federation is neutral on this bill. Finally, sections 1, 2, and 3 ensure parity between public and private projects. It does so by taking the current statute from Minnesota 337 and the changes just mentioned and put that language into the public section of statute 1571 and 1572. Now, there's certainly an argument out there that 337 and its anti-indemnity provisions already apply to state agencies, but some have argued that it doesn't or that it is vague, so this is belt and suspenders to eliminate any ambiguity. It's important to note, if this bill is passed, a general contractor can still require a subcontractor to pay for and insure the general contractor for any costs related to the subcontractor's own fault or negligence. The right to require someone to be responsible for their own fault is protected in 337.02. The right to require insurance coverage to protect for vicarious liability is specifically protected in 337.05, subdivision 1D. This bill does not change that, and it brings that those same protections into Chapter 15. There's a lot of support for this bill. It's actually now 25 organizations, including a host of trade unions, trial lawyers, and many construction employer associations. In the past, the public owners and the AGC have raised some concerns. We've had meetings over the years, and we've asked for suggestions, and we'll continue to listen. But the status quo needs to be changed if we want to create clear and fair public policy. In closing, this bill is about fairness and removing barriers for small and emerging businesses, as well as leveling the playing field for the contractors using unreasonable contract terms. Please pass House File 865. Thank you.
All right, next on the list I have Tamara Sunby and then Paulita LaPlante on deck. Please introduce yourself for the record and then proceed with your testimony.
Right. Thank you, Madam Chair. And my name is Tamara Sunby. I am proud owner of GTS HVAC Incorporated. We're a woman-owned DBE HVAC company. We have been in business for 17 years, and we have 3 trucks in the field. We've made it through the pandemic, and we're working through this recent Great Recession. And I hope to stay in business for another 17 years. I hope to hand the business down to my daughters or sons, but many of the contracts I'm being asked to sign could put us out of business in the blink of an eye for someone else's mistakes. The defense demands that some general contractors and public owners are requiring they put my business on the hook for their actions and their lawyer fees. It's not fair, it's not right, and it's got to be fixed now. Why should I have to pay for or insure someone else's mistakes, especially someone who I have no authority over? Seriously, I ask myself, is this even legal in Minnesota? Public owners are begging small, women-owned, minority-owned DBE businesses like myself to come on board on public projects. Yet, they're expecting me and us to sign these unfair contracts. You have an article in your materials about MnDOT failing to meet their DBE goals. In that article, it feels like they're blaming us, the DBEs, for failing to meet their goals. But how can I even consider a job when I have to sign their non-negotiable contracts and enter into these contracts that are very risk-filled? I have had to turn down a number of jobs or potential job opportunities, both public and private, because of non-negotiable defense provision. It's impacting the growth of my business. I've also had to hire attorneys to argue about terms before I even know if I get the job, which means I'm paying for the project I may not even get. If I do get the job, it's already cut into my margin before I go on site, which means when I arrive, I have to perform perfectly. I know many of my peers are signing these contracts so that they can get work, and I know many of them are signing these contracts and they don't understand the amount of risk they're taking on, or they're being shamed and bullied into signing them. This leaves only a legislative option, which means we need your help. I'm testifying today because I want to help end this absurd, unfair practice for myself and others. It's a bit daunting, but I'm proud to be testifying here today with another women-owned business in the midst of Women in Construction Week. She's also willing to stick up for our industry, even if no one else will. Please pass House File 865 and bring some common sense back to Minnesota construction contracts. Thanks for your time today, members.
Thank you for your testimony. Paulita LaPlante, please introduce yourself and proceed with your testimony.
Thank you, Tamara. Madam Chair and committee members, my name is Paulita LaPlante of Inver Grove Heights, the owner of Prescription Landscape Incorporated, a woman-owned business enterprise that was founded in 1980 and headquartered in St. Paul, Minnesota, with branch offices in Crystal, Shakopee, and Sauk Rapids. Duty to defend reform is important to equity in construction contracts. Prescription Landscape is a privately held, locally owned commercial landscape company with approximately $40 million in revenues, depending on snowfall totals. We employ a year-round staff of 150 and grow to twice that size in the winter. We have multiple land care service lines, one of which is landscape construction. That service line is our only union division, and it is less than 10% of annual revenues. Most of the jobs we bid are large, so we routinely subcontract aspects of our work to small business WBE, MBE, and DBE subcontractors with whom we have had years-long relationships. This helps their businesses since we pay for the insurance to indemnify their work and can afford bid bonds when required. While this sounds great, we are leery of growing our construction service line because the contract language from some of the contracts on which we bid can shift all the risk of loss to us if there is even the thinnest nexus between the claim and our work. Unlike Tamara, our company can afford to turn away work if it poses too great a liability risk for us. However, that means we are turning away work we would be able to give our subcontractors as well. You've had the opportunity to read contract language, but the clause that always causes us to reject work includes the statement, quote, contractors' work or presence on the property, including but not limited to any negligent acts, end quote. The practical effect of this language shifts the entire risk of loss to our shoulders for an unknown universe of claims. We are 100% willing to indemnify our work and that of our subcontractors as it is defined in our scope of work. However, when a contract includes broad statements about our very presence on a property, it is easy to see that definitions can become obscured and legal risks heightened. Our insurers rightfully balk. I respectfully request that you pass this bill and enable us to continue to grow our business and contribute to the growth of our small business partners. Thank you.
All right, thank you for your testimony. I will note in your list of supporters, we have the heat and frost insulators, and I think it's a really missed opportunity to not have their letterhead with their logo in our packets today. Sorry, that was a union joke. Next up, I've got Jim County and then Cameron Boyd. Yeah. Google the heat and frost insulators logo. You won't be disappointed. Please introduce yourself and proceed with your testimony.
Good morning, Madam Chair and members. My name is Jim County, and I'm Deputy Chief Counsel at MnDOT. Now, public contract owners certainly support the goal of having contracts that are fair to all participants in the construction process. I'm here today to express my concern about what I think are a couple of unintended consequences in this bill. Consequences that I believe increase the likelihood and cost of litigation on public construction projects. And I'll briefly discuss two of these risks. First, the duty to defend and the duty to indemnify are very different duties, and this bill conflates those two duties. This bill then conditions the duty to defend to the extent of a party's liability. But to be effective, a duty to defend must logically be triggered by a claim and not by the allocation of liability. In the insurance context, the Minnesota Supreme Court has said that the duty to defend an insured arises when the claim is arguably within the scope of a policy's coverage. Now, that's an insurance case, and we're talking here about a contractual obligation to defend. But if that contractual obligation to defend only arises when liability is determined, it seems to create a very odd situation where a general contractor could refuse the owner's tender of a case and say, I'm not responsible for defending this case because the extent of my liability is not determined yet, even though the general contractor's insurer would be under an obligation to defend the insurer in that case. So we think the unintended consequence is that public project owners will have to defend cases that really should be defended by a general contractor. In 2022, MnDOT turned 11 tort cases over to general contractors. Now, these weren't lawsuits. These were claims that came in through an administrative process, but these are cases where MnDOT did some investigation, determined that MnDOT didn't have any fault or liability, and turned the cases over to the contractor to resolve them. I bring that up to show that this is, has real world consequences for public project owners. And I think kind of an equally concern arises from the insurance language in the bill, which I think actually doesn't provide additional clarity and maybe in fact makes things less clear. Now, the bill, the insurance language would leave a specific reference to builder's risk insurance, which I think calls into question whether public project owners would be able to require other types of insurance that we typically require on public projects, such as commercial general liability insurance, commercial automobile insurance. Sometimes we even require things like marine liability insurance if we're going to be building a bridge pier off of a barge or something like that. My point is that each construction project is different, and we as public project owners need to make sure that we retain the right and the ability to customize insurance coverage to the risks of a specific construction project. Thank you, Madam Chair.
All right, thank you for your testimony. Next, I have Cameron Boyd, and then I have Patrick Hines on deck. Please introduce yourself and go ahead.
Thank you, Chair Becker-Finn. My name is Cameron Boyd, and I'm the General Counsel at the Metropolitan Airports Commission. A lot of my comments will echo what Jim just told you. The Metropolitan Airports Commission is, of course, very concerned with lowering barriers to entry and fostering more competition in our construction contracting. We have a strong interest in supporting more DBE and TGB contractors working out at the airport. The problem with House File 865 is that, as Jim told you, it confuses the duty to indemnify with the duty to defend. And we have no objection to what this bill would do with regard to the duty to indemnify. The idea that only negligent parties or at-fault parties would have to defend claims is a great one. The problem is that the claim is how you know who the negligent parties are. And so at the front end of a dispute, you don't know who was at fault or who was negligent. And of course, the front end of a dispute is when you have to determine whether that duty to defend applies, because that's when the defense begins. Because of this, House File H65 would force more parties to actively defend claims for which they have no fault. As an example, if their hammer falls off of a construction project and injures a third party, someone who's not a worker at the construction site, you may not know which contractor, which subcontractor is actually responsible or at fault for that hammer falling and injuring someone. But you do know with reasonable certainty that the owner is not, in fact, at fault because the owner does not have representatives out there using hammers on the job site. Under House File 865, what would happen or could happen is that an owner would be sued, because plaintiffs tend to sue everybody that they possibly could. And the owner, if looking at the terms of the complaint, determined there's no chance that the owner is liable or at fault for the activities, would tender that defense to the contractor. And as Jim told you, there is a risk under this bill that that contractor might just say, I'm not at fault, so I don't have to defend you, even though they agreed in the contract to do so. And the bill does not give any guidance to how to resolve that conflict. If you look at the terms of the complaint and a party may well be at fault and they say, I'm not at fault, there's ambiguity there. We would be forced to rely on judges down the road to determine how this would actually come out. And so rather than eliminating ambiguity, as we've heard from some other testifiers, I think this bill actually introduces more ambiguity. I'll conclude my comments there.
All right, thank you. Patrick Hines. Please introduce yourself for the record and proceed with your testimony.
Thank you, Madam Chair and members. My name is Patrick Hines with Messerly & Kramer, and in the interest of time, I'm here testifying on behalf of two organizations, both the Minnesota Contractor Coalition and the Associated General Contractors. I'd like to start out by noting the statute that is attempting to be amended was the result of a compromise 10 or so years ago that's been referenced a few times, when subcontractors came to the legislature and asked for a change in the law to prevent them from having to indemnify other parties for their own negligence. And that bill was passed after much discussion and a compromise was reached. I disagree with the notion that there's a loophole or that the spirit of that law is not being followed. The duty to defend is different than liability, and it's different than indemnification. And that's always been the case, and that's why the current law does not include defense as part of an indemnification agreement, because they're two different things. And if we step back and look at what happens in the real world on a project, let's say I'm a landscaper, I installed an irrigation system, that irrigation system floods property, causes damage. I get sued as the landscaper. What will also happen is that the general contractor will get sued as well, even though the general contractor didn't perform any of the work. The reason is that Minnesota statute makes the general contractor vicariously liable for the work of the subcontractor. And the general contractor can't delegate away that responsibility. Minnesota statute says general contractor is vicariously liable, even though they didn't perform any of the work. It was the subcontractor who performed the work. So as a subcontractor, if my irrigation system flooded someone's property and I get sued, I have a complaint in my hand. I send it to the insurance company. The insurance company doesn't investigate what happened. It doesn't try to determine who's liable or who's at fault. It looks at the complaint and it looks at an insurance policy. And it asks, does this policy cover the company in the complaint? Yes. Is this policy in effect at the date of the alleged negligence? Yes. Does this allege the scope of work that's covered by the policy? In other words, is it saying that the irrigator, the person installing the irrigation system was at fault? Yes. In that case, the insurance company defends the claim. That means they hire an attorney and the attorney defends the claim. That lawsuit will also contain a couple of paragraphs that says, based on information and belief, Acme General Contractors was the general contractor on this project. By operation of Minnesota statute, they are vicariously liable and they will be sued as well. The defense obligation in the contract simply states that the one attorney retained by the insurance company of the person who did the work will defend both the subcontractor and the general, because at issue is the subcontractor's work. That's the only thing at issue. And so with this bill, what it does is it means, in addition to having the insurance company for the subcontractor hire an attorney, an insurance company for the general contractor is going to hire another attorney who ends up defending the work of the sub.
I'm going to have to ask you to wrap up.
So it really is, what we're talking about is the subcontractor's insurance paying to defend the claim against their work. All the bill would do would create more opportunity for attorneys like me to be involved in defense cases, and I assure you that no one wants more attorneys like me being involved in these cases, because it just runs up the costs and it makes it harder to reach a settlement.
Thank you for your testimony.
Thank you.
Attorneys love to tell us stuff, don't they? I will say too, to all the contract attorneys, I always think it's interesting when people tell us about, oh, there was some compromise, some deal was made 10 years ago when almost none of us in this room were here. And as we know, that means none of us were party to that agreement. So always an interesting argument here in the legislature. Any other members of the public wishing to testify on this bill? All right, we'll move on to member discussion. Representative Niska.
Thank you, Madam Chair, and Representative Hollins or Representative O'Neill. We heard from MnDOT and the Metropolitan Airport Commission about, gentlemen, I'd like you guys to be on deck because I have some questions for you. We heard from them about their concerns.
Not exactly how that works, Representative Niska, but you can go ahead.
If you would allow me, I think that there is some questions we.
All right, let's get to the point.
Yeah. Representative Hollins, have you heard from them about any suggestions about how to clarify the duty to defend to account for the concerns they say they have about how this would operate?
Representative Hollins.
Did you?
From either of the
Did I hear from
agencies that
them?
testified.
I received a documentation that they said they would prefer to see in place, and my understanding is it basically codifies what's currently happening in law right now. So,
Representative Niska.
Thank you, Madam Chair and Representative Hollins. Is there something constructive that we could do to the bill that would add clarification around to address their concerns, or what is the nature of the suggestions they've given about potential changes to the bill?
Representative Hollins.
I mean, I can certainly send you the language if that would be helpful, but I don't think it gets at the core issue that we're looking at here, which is, equity and fairness in contract making. And I think that's the concern that we have and why we didn't offer it as an amendment, because it really doesn't address the core issues that have been brought to us by subcontractors repeatedly.
Representative Niska.
Thank you, Madam Chair. And what I would like to hear from MnDOT or the Metropolitan Airport Commission is maybe some sort of explanation whether, if the bill passes the way it does, whether they would actually take the legal position under the bill that they're taking today. I highly doubt it. And so I'm curious as to whether
Why don't you pick one person? I'll let you ask one of them. But yeah, just to remind folks, this isn't like, it's not like a courtroom where we're going to call up a bunch of people for.
I appreciate that, Madam Chair, and I don't mean to
just give me a sec.
Yeah,
so just let me know. We can have one of them, but you can pick one of the attorneys to come up here.
Yeah, I'd love to hear from Mr. County if you would indulge me.
Yeah,
Madam
just
Chair.
remembering we've got 9 other bills on the agenda today. So, Mr. County, thank you for coming back up. Go ahead with your question, Representative Niska, while he's here and can actually listen.
Thank you, Madam Chair. And Mr. County said that he referenced Minnesota Supreme Court precedent and other case law about the duty to defend and duty to indemnify in insurance law. And I'm curious, Mr. County, whether in a dispute in the future in which the duty to defend is, if this bill were to go into effect, would you take the position that the project owner has to defend, or would you take the position, would the Department of Transportation take the position that the duty to defend is something that you can place on the general contractor based on the nature of the claim, rather than going all the way down to an ultimate finding of liability?
Mr. County.
Thank you, Madam Chair and Representative. Our concern is that if MnDOT were to have a claim that we didn't think we had a share of liability, we would hand off or tender that claim to the general contractor. And we believe that under the language of the bill, the contractor could essentially refuse the tender of that claim, saying the extent of my liability is not established yet. So MnDOT would be forced to defend that claim based on the general contractor's refusal to do so. I hope that addresses your question, Representative.
Representative Niska.
Thank you, Madam Chair. And Mr. County, you understand that that is the actual exact legal question that's resolved in every insurance coverage dispute surrounding the duty to defend. Why would this be any different?
Mr. County.
The insurance coverage dispute, the question is about whether something is arguably within the extent of the policy. And under this language, we believe that the duty to defend wouldn't even arise until the extent of liability is allocated, and we don't know how the extent of liability is allocated unless you go through a lawsuit or a settlement or something like that. So it essentially sort of puts the cart before the horse, so to speak.
Representative Niska.
Thank you, Madam Chair. I'll just comment that, Mr. County, I don't think that the legal question is going to be any different, because the legal language is exactly the same. And we already have a detailed body of law in the insurance coverage context about what the duty to defend is. And I agree with you with your description of it. This doesn't do anything different. It just just asks the courts to ask those same questions in this context. And so I expect that the Department of Transportation and Metropolitan Airport Commission in that future case under this bill will take exactly the opposite position of what you're taking and will win because the Minnesota Supreme Court, I've looked at a lot of insurance contracts. They use language duty to indemnify and defend, just like what we're putting in here. And so I don't think that, my opinion is that your views, your concerns are not well-founded. Thank you.
All right, Representative Johnson.
Chair Becker-Finn, Representative Hollins, Representative O'Neill, unfortunately, thank you for bringing this forward. I was here 10 years ago when we went through this.
Well, let's make it brief, Representative Johnson. We don't have full story time today.
And the arguments that the general contractors are bringing forward are the exact same arguments back then. Nothing has changed. Unfortunately, what we tried to fix last time with the negotiated settlement didn't work. General contractors are responsible for the work and the safety on a job site. When we built a facility for my father-in-law, the general contractor was never there. We had a union putting in a sprinkler system that didn't put enough straps in. That fell down. And water on bowling lanes do not work well. Fortunately, it was in the kitchen, but we had to be shut down for a week to get them there to fix the system because the sprinkler system actually fell from the ceiling. General contractor wasn't there to make sure it was done properly. Our cooling and refrigeration system is not where it's supposed to be because the general contractor wasn't there to put them in, make sure that they were properly placed. Our heating system is not what we expect because the general contractor wasn't there to do the job to make sure things were done right. It cost us a lot more money because of those mistakes because the general contractor wasn't there. A bill like this is going to make sure that the general contractor is on site, making sure work is done properly, and making sure safety is in effect. So when a hammer falls and actually hurts somebody, they know who the hammer belongs to and who to go after. But the general contractor needs to be on site. And if this bill makes sure the general contractor is on site, thank you for bringing it forward.
All right, and Mr. County, you're excused. Representative Hollins and Representative O'Neill, any closing comments?
Well, thank you. Thank you, Madam Chair. Thank you, committee members. I want to thank Representative O'Neill for being here with me and co-presenting the bill. I think it's important to recognize that this is an issue that we can come together on. It was wholly bipartisan in 2013, and I think we can be bipartisan on it again. When you think about this issue, what I want you to consider is who makes the most money off of a job, who has the biggest budget, who has the most power in negotiating a contract. This bill is about basic fairness and common sense, and asking companies with the least power and the fewest resources to bear the burden is just patently inequitable. This bill is going to help small businesses, businesses owned by economically disadvantaged and historically disadvantaged groups, and workers all across the state of Minnesota. We just want parties on construction contracts to be responsible for their own actions and their own legal fees. And we want all parties to have skin in the game. This includes general contractors who have the overarching responsibility to ensure job site safety. I would urge a yes vote. Thank you.
All right. With that, I will renew my motion to recommend that House File 865 be placed on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails. All right. Thank you both for being here. Next up, I've got Representative Edelson. I will move to recommend that House File 2234 be placed on the general register. Representative Edelson, welcome to the committee. Please tell us about your bill.
Good morning, Madam Chair and members.
Audience, if we could be quiet, we have work to do. Thank you. Representative Edelson.
Thank you. This bill, I don't think is going to be as exciting as the last one, but
Never know.
You never know. House File 2234. Section 22 is what is before Judiciary today, so that starts on page 24 of the bill. So what Section 22 of the bill does is it codifies home and community-based services, also HCBS, known as Critical Incident Review Process. The HCBS Critical Review Process currently operates as a pilot. The review process includes counties, omnibuds staff, state agency staff, regional quality councils, and other community members. In codifying the critical review process, Section 22 of the bill clarifies the proceeding and records of the review team. Our conditional data, Representative Scott is going to love that one, or protected non-public data, sets parameters around the admissibility of opinions and facts that may arise as part of the critical reviews, and it identifies the actors involved and types of incidents reviewed and requires recommendations to reduce the severity of the amount of the critical incidents. And with that, Madam Chair, I just have one testifier, Director Grom.
All right, Director Grom, please introduce yourself and then proceed with your testimony.
Thank you, Madam Chair. My name is Christy Grom, and I'm with the Department of Human Services. So this is a DHS policy bill that was heard in this committee last year for members who may have been on the committee. And this is, as Representative Edelson mentioned, related to our HCBS, or Home and Community-Based Services Critical Incident Review Team. We call this the culture of safety at the department. And for those who aren't steeped in the HHS world, I know many of you here are, but HCBS, when we talk about home and community-based services, these are generally services that occur in a person's own home or in their group home. So we sometimes call those community residential settings or corporate foster care settings. And so this is a newer critical incident process that we are using at the department. It's not yet formalized in statute, which is what we're hoping to do with this bill. We began this in about 2019, and what we really want to do with this project is not eliminate our maltreatment investigations and other kinds of investigations around critical incidents like medication errors or elopement or potentially even, an illness or an injury. But we want to enhance that and really take a step back and understand, instead of just blaming a staff person or a setting, which sometimes there is accountability that needs to be had there, a lot of times the system and the way we set up our rules and our laws contribute to these critical incidents themselves. And so kind of in the midst of a workforce crisis, in the midst of really trying to better serve people in their homes and in their communities, we want to understand as a system, where do we need to take accountability and where do we need to make changes? And so that's exactly what this critical incident review team does. This is a model that exists for child critical incidents and fatalities as well. I believe it's in Chapter 256, the same area where this is being codified, and that language looks very similar to what is in front of you in Section 22. And so this is something that's used in other industries and as aviation, nuclear facilities, even in hospitals, and it's sort of coming into the space of human services, and really an effective way to just improve safety and also retain our workforce. So this language has been endorsed by the Culture of Safety Steering Committee, which includes about 8 counties, as well as the ombudsperson and several other individuals and advocacy organizations. And really the point here of this language is just to make sure that we've got really clear expectations around, and so that people feel comfortable to volunteer to be a part of these critical incident reviews, that they understand how the information that they share is going to be used. And with that, I'm happy to answer any questions and would appreciate members' support.
All right, are there any other members of the public wishing to testify on this bill? Not seeing any, we'll move to member discussion. Representative Moeller.
Thank you, Madam Chair, and thanks to the department and to Representative Edelson for this bill. And I carried this in past years, and I just want to say, too, we really worked out some of the issues surrounding data in previous years. I know Representative Scott, we worked on some of this language in the past. I mean, Koji has looked at it and provided feedback. And so there was a lot of good work that went into crafting this language that's before us today. So just wanted to point that out and thank you for bringing this bill.
Representative Scott.
Thank you, Madam Chair. And I just wanted to echo what Representative Mueller said and thank you to the testifier for circling again with all those interested parties in what you're bringing today. And so I would encourage member support.
Director Grom is very thorough. I know we all appreciate their work on various bills. Any Representative Curran?
Thank you, Chair. Thank you for this bill. And I know we've talked before, Director Grom, you're aware of my 20 years on the provider side of this. So of course I have a quick question about it. So just looking at the data that's collected, my biggest concern would be data from the CSSP and whether or not that would become public or if there would be identifying information redacted from that.
Director Grom.
Madam Chair, Representative, that's a great question. And actually, since we're very specific in this committee, especially, the CSSP is no longer the right term, so we need to amend that. It's actually the Community Support Plan, but that is all considered confidential data, is my understanding, under Chapter 13, or Section 13.02.
Great, thank you.
All right, thank you. All right, with that, closing comments, Representative Edelson.
Support the bill.
All right, great. With that, I will renew my motion to recommend that House File 2234 be placed on the general register. All those in favor, please say aye. Aye. Opposed? The motion prevails. Next up, we've got Representative Brand. I will move to recommend that House File 1272 be placed on the general register. We do have an amendment. I will move the A6 amendment. Representative Brand, if you can tell us quickly what the A6 does.
Yeah, thank you very much for the opportunity to hear the bill today. The A6 it modifies just a little bit when we're talking about types of railroads. And so this is a two-person crew bill. And we realize there are different types of passenger corridors. There's also freight corridors. This section addresses a shared corridor, and also, in conjunction or working with Representative Hornstein on this, this is the amendment that addresses light rail as well in that corridor. So I would ask for a yes vote.
All right. All those in favor of the A6, please say aye.
Aye.
Opposed? The motion prevails. The amendment is adopted. Representative Brand, please tell us about your bill as amended.
Thank you very much. So I believe that every train should have a two-person crew in the cab of a locomotive. Right now, most trains in Minnesota do. However, there's no statute to articulate this in law. There also is no federal law or regulation to address a minimum-sized crew for trains. However, there are such regulations in place for commercial airplanes in the skies. 2 people. Unlike planes, trains are up to 3 miles long and carry many hazardous and dangerous chemicals each and every day. You might think of one of the latest incidents that happened in Ohio to get some perspective on how hazardous and dangerous that could actually be. And if a railroad wanted to, they could put one person in the cab and actually have somebody drive alongside the train with an automobile to monitor the train. And I, as it goes from point A to point B, and I actually can't think of anything more absurd than that happening in a rural area especially. A minimum crew size is a public safety and also a workplace safety issue. This is a perennial issue that we've addressed at the legislature since 2018, although it hasn't quite passed yet. And in light of 2 recent derailments in Ohio, I think this is the year we will actually pass this bill. As you will hear, trains are now several miles long, but they never used to be. In 2016, for a little bit of background as we set the frame for the conversation today, the Federal Railroad Authority proposed a federal 2-person crew rule. In 2016, the Trump administration shelved the rule, arguing that there was no safety data to support the decision. However, a federal court struck down that decision, and until we have such a rule in place nationwide, I believe we should honor the profession by setting a floor on crew members to 2 and not less than that. To be clear, there is no preemption by federal government in place on crew size. And so we have the ability as a state legislature to articulate our concerns into law. Today, I actually have rail workers with me to talk about their experiences and why they think this is also essential. As you will hear today from my testifiers, there are issues that happen on trains, real emergency situations, and having more than one person aboard is a benefit to the community. And so without further ado, I will turn it over to my testifiers.
All right, I've got Nicholas Kadich and Joel Mueller. And just to remind everybody, including our testifiers, this bill is here because of the penalties portion of the bill. So if we can keep it focused, that would be really great. Please introduce yourself for the record and proceed with your testimony.
Madam Chair and committee members, my name is Nick Kadich, and I am the Minnesota Legislative Director for Smart Transportation Division, representing railroad conductors, engineers, and yardmasters. So the bill before you, House File 1272, is necessary right now. Most railroad operations are currently utilizing 2 crew members, and we as frontline workers are telling you we must maintain 2 people on our trains in Minnesota. So railroads utilizing the media have begun announcing their plans to eliminate 1 crew member. This is not currently feasible and would be entirely trial and error. Minnesota's communities are not experimental proving grounds for railroads to exploit. So the penalties written in this bill are appropriate. The fines are stepped in a way that discourages repeat offenses. Railroads hold no regard for state laws in our experience, and without stiff monetary penalty, they will not comply. So this bill language has been carefully crafted to avoid anything that would cause it to be federally preempted, and Minnesota needs to protect its towns, citizens, and resources with this bill. So thank you, and I'll stick around for questions.
All right, thank you. Joel Mueller. Please introduce yourself for the record and proceed with your testimony.
Morning, Chair Becker-Finn, members of the committee. I'm Joel Mueller with the Brotherhood of Locomotive Engineers and Trainmen. I have over 28 years of experience in the rail industry, working as a brakeman, a conductor, and I'm currently working as a locomotive engineer. I want to begin by saying this bill will only maintain the current standard of 2 people on a train crew. Over the years, trains have gotten longer, more technology has been introduced into the cab of the locomotive to the point of creating task overload for the locomotive engineer. In your packet, you'll notice there's a picture of a cab of a locomotive, and you will be able to see the extensive amount of controls and devices that are needed to safely operate a train. As trains have gotten longer and riskier to operate, railroads have attempted to make crews smaller with the goal of operating trains with just 1 crew member. This cost reduction approach eliminates the necessary safety margins and redundancies, offloading that risk onto the communities, with potentially tragic results. This legislation would create a permanent requirement for railroads to operate trains with at least 2 people in Minnesota, ensuring that sufficient well-trained railroad staff are available for safe operation and to respond in the aftermath of a derailment or a crossing accident. With the advent of a business model called precision scheduled railroading, or PSR, railroads have chosen to focus on cutting costs to increase profit margins, often at the expense of safety. In an effort to reduce costs, we have seen railroads ignore state laws and federal regulations, putting the safety of their employees and the public at risk. With that in mind, there must be an enforcement mechanism available to the state should this legislation be passed. The penalties in this bill are inappropriate to ensure the railroads will comply with the law. I'll be happy to take any questions you may have. Thank you.
All right, thank you for your testimony. Next up, I have Sarah Erickson and then Thomas Fuller on deck. Oh, I guess Thomas is just here for questions. There we go. Please introduce yourself for the record and proceed with your testimony.
Good morning, Madam Chair, committee members. My name is Sarah Erickson. I'm here today on behalf of the Minnesota Regional Rail Association. I will be very brief. Earlier on today, you heard that several states have enacted train crew staffing laws, and only a few have found their laws preempted federally. However, every state where preemption has been litigated, the courts have found the laws federally preempted. Where these laws are on the books, many states have not litigated because the laws are simply not enforced. These laws are not enforced either because the laws have been found to be preempted or the states understand that they do not have the authority to do so. This bill is preempted by the Federal Rail Safety Act, which states laws, regulations, and orders related to railroad safety and laws, orders, regulations related to security shall be nationally uniform to the extent practicable. This is express preemption. The act goes on to say a state may adopt or continue enforce a law, regulation, or order related to railroad safety until the Secretary of Transportation prescribes a regulation or issues an order covering the subject matter. What this means in English is that states are allowed to adopt a law on rail safety unless the federal government has already considered the issue. A good example of this test of preemption is the Wisconsin case BNSF versus Doyle. The court found if the FRA has acted on an issue of crew size in this area, then a crew size requirement is preempted. At the time of Doyle, the FRA had not acted on the question of crew size. However, the Doyle case was specifically about hostelers services, and I don't know what they do, and I should maybe find that out, and utility and employees. And as you can see on line 1.9 of the bill, House File 1272 does not apply to hostelers, services, and utility employees. The case tested federal preemption, and the House file in front of you recognizes that. The Doyle case relates to crew size because the case law found that if the FRA considers a rule on crew size but decides not to issue a rule, that decision is still the FRA taking action. So the question becomes, has the federal government acted on crew size? You heard testimony today that there is currently no federal law or regulation on train crew size. However, the FRA has looked at and decided not to take action on this issue. That inaction is enough for preemption to take hold. Examples of this were in 2009, 2013. In 2019, the FRA withdrew their notice of rulemaking to determine that no regulation was needed. This has happened in 2020, and it's happened in 2022. Finally, you will hear it argued that the state has the authority to set laws relating to safety regardless of federal preemption. That's true, but in order to do that, the state must meet all requirements for a three-pronged test. First, the state can regulate it if necessary to eliminate an essentially local hazard. House File 1272 does not eliminate an essentially local hazard. It's a statewide bill. Second, the state law cannot be incompatible with federal law. House File 1272 is preempted by federal law. And finally, third, the state cannot unreasonably burden interstate commerce. House File 1272 directly interferes with interstate commerce, suggesting that trains would have to stop at the border to add or drop crew members. Madam Chair and committee members, the Minnesota Regional Rail Association believes this bill to be preempted by federal law, and as a result, we ask for a no vote. Thank you.
All right, thank you for your testimony. Are there any other members of the public wishing to testify on this bill? All right, please introduce yourself and proceed with your testimony.
Thank you, Madam Chair. My name is Thomas Fuller. I'm an attorney at Hunnigs, Leneve, and Kvass. Our firm has been representing injured railroad workers for decades. I'm here to urge everyone to fully support this two-person crew bill. And doing so will reflect a deep commitment to safety in a real effort to protect Minnesota citizens and railroad employees. Arguments against this bill are entrenched in putting corporate profits over safety, and we deserve much better, and the railroads should put safety first when operating throughout our communities. As it relates to federal preemption, what you didn't hear was an actual law that touches on crew sizes from the federal government. Therefore, the railroad's arguments are unsupported when it comes to preemption. For preemption to be established, the railroads must establish specifically a federal regulation that substantially subsumes the subject matter of relevant law. As the Honorable Judge Tony Leung stated, the railroad must establish more that a regulation touch upon or relate to a subject matter. For covering is a more restrictive term, which indicates that preemption will lie only if federal regulations substantially subsume the subject matter, of which there is none that the railroads can point to. As I indicated, here there is no federal law that would truly preempt a state regulation on safe crew sizes. The cases relied upon by the railroad to reject this safety bill before you are specific to those particular states. Specifically, Illinois, where the one federal regulation, the Regional Rail Reorganization, or 3R Act, was in effect, applied regionally to those states at issue, of which Minnesota was not one. Furthermore, the 3R Act is concerned with economic matters. And as the court in Illinois recognized in that decision, the 3R Act is not concerned with safety. A prohibition on Minnesota from passing laws related to crew size will have doubtless implications for safety, not only for railroad workers, but the citizens of our communities. There is no similar law that would even apply to Minnesota to preempt this bill before you. Minnesota should adopt and enforce this two-person crew bill to protect its citizens and ensure that railroads operate safely in Minnesota communities, and they are protected, putting safety first in these railroad operations. Thank you, Madam.
All right, thank you for your testimony. We'll move on to member discussion. I've got Representative Feist on the list, and just to remind people, the reason this bill is in our committee is about the penalties. Representative Feist.
Thank you, Madam Chair. My question related to preemption. Should I not ask it?
I mean, we've got 6 minutes. I got one more bill I need to pass. So if you can keep it really tight.
It is really.
Okay, Representative Feist.
My question is just, Ms. Erickson cited to a case of Doyle, and I was just curious what circuit court that is, or if it was Supreme Court. That was my question. Seventh.
Okay, it's the Seventh Circuit is what we're hearing. And in the future, if folks want to get into the weeds in a bill, then you got to share the bill with the members of the committee. We can't discuss something that only one or two people have read. That's just not ever going to be helpful. Any further member discussion to the bill? Representative Frederick.
Thank you, Madam Chair. Just a quick clarification, there was a lot of talk about preemption, and Ms. Erickson said that there is not any federal law, but then she also said that there is a federal law, and I'm just curious if there is a federal law, as she stated, what is that law?
Ms. Erickson.
Madam Chair, Representative, sorry if I was confusing. Currently in place, there is no federal law regulating two-person crew. I think my point is that the FRA has taken this issue up repeatedly and decided not to comment on it. And from our position, that triggers preemption. Their decision not to do something is the same as them deciding to do something.
A non-existent law can't preempt something that we're doing in state law. So, and also, as we pointed out, it was just a Seventh Circuit decision. But, all right, any further discussion to the bill? Representative Scott.
Thank you, Madam Chair. And to the bill's author, how would the fines be determined as to who would be responsible to pay for them, whether that's individually or at a company level?
Representative Brand.
When you look at the law, it actually will be a judge's decision to fine, and it will be based upon how many violations have occurred, and those violations will ramp up higher fines to the individual companies.
Representative Scott?
Okay, thanks.
All right. Representative Brand, any closing comments?
Great bill. Thanks a lot for supporting it. I appreciate it if we could pass this bill this year.
All right. I will renew my motion to recommend House File 1272 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you, Representative Brand. Members, we're going to lighten up our bill packets for this evening, so I'm just going to stay here and move House File 1581. This is the reviser bill. So for new members, this is the cleanup bill. It's always a big, fat bill with references to all kinds of little things that need to be cleaned up. Yep. We've got the deputy reviser here. If you just introduce yourself for the record and go ahead.
Thank you, Madam Chair and members of the committee. My name is Jeff Case, and I'm here on behalf of the reviser's bill. This is our annual technical bill, as the chair said. It makes corrections to Minnesota statutes. It goes through a process of careful screening to make sure that none of the corrections contained in it are substantive or controversial in the legislature. It is also shared with House Research and Senate Council, as well as state agencies. That is the bill. I'm here to answer questions if there are any.
Yep, and then we do have the A23-0031 amendment, which just cleans up the numbering in the bill. Any discussion to that amendment? All those in favor, please say aye. Aye. Opposed? All right, the motion prevails. The amendment is adopted. Any discussion to the bill as amended? Representative Feist.
Thank you, Madam Chair. Thank you so much for your important work. Just to warn you, I've been emailing with the governor because I think we need a signing ceremony for this bill. And we appreciate you. Thank you.
Yeah, we didn't want to make, our revisor staff are so critical to everything we do here. We didn't want to make you come back later this evening, so wanted to fit this in. With that, I will renew my motion to recommend House File 1581 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed? All right, the motion prevails. We're about to recess, but members, if you can put the bills that we didn't get to keep them in your folders, that will save our staff some time, and that big, huge 1581 can come out of your folder, and then that's a little, maybe we like getting our work out carrying heavy folders, but we won't need that one for this evening. So with that, we are in recess.